Hello dear students, today we are going to study about Companies Act 2013. The Company Act 2013 is an act of parliament which regulates the incorporation of a company, responsibilities of company, directors and dissolution of a company. Now the 2013 Act is divided into 29 chapters containing 470 sections against 658 sections of Companies Act 1956. Now the Act has replaced the Companies Act 1956. Now after getting the assent of the president, the Companies Act come into being force. Now today we are going to study about different features of Companies Act and what are the provisions that have been added. Now the 2013 legislation which stipulates that it increased the responsibilities of corporate executives in the IT sector, increasing India's safeguard against organized cyber crimes, allowing CEO and CTOs to be prosecuted under the IT failure. If they fail to comply with certain provisions of the Act, they will be criminally liable. Now, NCLT. So, what is NCLT? NCLT is a National Company Law Tribunal which is outcome of ERAD committee. Now, NCLT was intended to be introduced in Indian legal system in 2002, but due to certain delays and other things, it was finally come into force with the notified with the Companies Act 2013. Now, what is NCLT? It's an quasi-judicial authority incorporated and dealing with corporate disputes that are civil in nature arising under the Companies Act. It means whatever the cases, the dispute that arising under the provisions of Companies Act will come under directly under the NCLT. Now, the constitutional validity of NCLT and specified allied provision contained in this act were re-challenged. They were re-challenged and they will be brought under the under NCLAT, and once it is further challenged, then they go to the Supreme Court. Okay. Now, once the NCLT was enacted, it was challenged in the Supreme Court, which the Supreme Court has stated that yes, it is legal and it has a constitutional validity. Now, the NCLT works on the line of normal court of law in a country and obling fairly without any kind of bias, determine the fact of each case and decide with the matters in accordance with the principle of natural justice as the lower court, high court and Supreme Court does. In the continuous such decision offer conclusions from the decision in the form of orders. Now, orders so formed by NCLT could assist in resolving situation, rectifying wrong done by any corporate or levying penalty and the cause which might alter the rights, obligation, duties and privilege of concerned parties. The tribunal isn't required to adhere to civil rules in the respect of to appreciation of any evidence or procedure law. Now, what are the major functions of NCLT? Registration of a company. The NCLT has been empowered in taking several steps from cancelling the registration of a company to dissolving any company. With this approach, NCLT can deregister any company in a specified situation when the registration certificate has been obtained by wrongful manner or illegal means under section 7, subsection 7 of the Companies Act 2013. Transfer of shares. Now, NCLT has been also empowered to hear the grievances of rejection of a company in transferring shares and securities under section 58 to 59 of the Act, where were at the outset were under the preview of Companies Boards Act 1956. It means that NCLT is empowered to transfer share, to hear the grievances, to transfer shares and securities under section 58 to 59. Deposits. Now, Chapter 5 of the Companies Act deals with the deposit and was notified several times in 2014. And the Company Law Board was prime authority for taking up cases under the said chapter. It means in Chapter 5, the Company Law Board was the prime authority for taking up cases regarding deposits. Now, such powers under the Chapter 5 of Act has been vested with the NCLT. Earlier, the problems or the grievances regarding the deposit is been with the power of Company Law Board. Later, with the enactment of Companies Act 2013, it come under the purview of NCLT. The unhappy depositor have now an option to reach NCLT for any kind of omission or any kind of seeking remedy or omission on a part of a company. that impacts their right as a depositors. Now the next point is, the next feature of a company NCLT is the power to investigate. As per the provision of Companies Act, investigation about the affairs of the company could be ordered with the help of application of 100 members. Now this is the new provision. Earlier there is a need for 200 members to file and request to investigate. Now it is only 100 member can request an NCLT to investigate, and once the application has been received, the investigation will be ordered. Moreover, if a person who hasn't related to company unable to pursue NCLT about the preference of a condition of ordering the investigation, the NCLT with power to order the investigation. It is precisely clear. If someone who does not have any related interest in the affairs of a company and would be, and in such circumstances, able to convince NCLT that yes, he have a prima facie evidence that yes, such situation arise, or request the NCLT and in a position and finally succeeds in convincing the NCLT, then the NCLT will order investigation. Now the next power of NCLT is freezing of the assets of the company. Now the NCLT is being empowered with freezing the assets of a company for using that at a later stage when the company comes under the investigation. Such investigation could also be ordered on the request of other specific conditions. The next power is converting a public limited company into private company. Now, Section 13 to 18 of Company Act 2013 read with the rules, control, or conversion of public limited company into private limited company. Such conversion needs an erstwhile confirmation from NCLT. Now, finally, the NCLT has a power under Section 459 of the Act for imposing specific condition or restriction which might subject to granting approval of such conditions. Now, Section 13 to 18 of the Companies Act, which mandates the rules for control of conversion of public limited into private company, and NCLT have a power under Section 459 of the Act to, under specific condition, to convert a public into a private company. Okay, now begin with NCLT. Now the NCLT under Section 408 of Companies Act 2013 is brought into. The first phase of Ministry of Corporate Affairs has set up 11 benches, 1 principal bench at New Delhi and 10 benches at New Delhi, Ahmedabad, Allahabad, Bangalore, Chandigarh, Guwahati, Hyderabad, Kolkata and Mumbai. Now there is the NCLT of principal bench, and NCLT second a New Delhi bench. There is 2 benches, one is the principal bench and second bench is at New Delhi, and then the rest 9 benches. Now NCLT Act confers powers on the central government to constitute NCLT and NCLT. Now appeal from NCLT lies with NCLAT, and further appeal from NCLAT lies with the Supreme Court. Now the aggrieved party, if in case is not satisfied with the judgment, file appeal at NCLAT, and if it is not further satisfied, then file with the Supreme Court, and everyone knows that the judgment of Supreme Court is binding on everyone. The tribunals will not be bound by the procedure laid down by the CPC 1908. It means that the tribunals are not bound by the Civil Procedure Code 1908, and which means that have the power to regulate their own procedures. It means that the NCLT has the powers to regulate their own procedures. Constitution. The Constitution of NCLT Section 408 deals with what does that means? It means NCLT is a successor of quasi-judicial body of Companies Law Board. It means it's a replacement of Company Law Board. The central government is to constitute the tribunal that shall consist of a president, such a number of judicial and technical members as may deem necessary. It means there would be a president as well as certain judicial as well as technical members which going to be form a NCLT. The president shall be a person who has been a judge of a high court for at least 5 years. Now, to qualify for an appointment as a judicial member in NCLAT, the person shall not be qualified for the appointment of judicial member unless and until he or she is or has been a judge of high court, is or has been a district judge for at least 5 years or has for at least 10 years as an advocate of High Court. These are the minimum qualification for being to qualify as an appointment for judicial member. Now, for qualification of technical member in the tribunal should fulfill the following qualification. Now, let's see what are the qualification. He may be a member of Indian Corporate Law Service or Indian Legal Service, out of which at least 3 years shall be in a pay scale of Joint Secretary of Government of India or equivalent. Or he could be chartered accountant who has been in practice for 15 years, or a company secretary who has been in practice of 15 years. It means for being a technical member, either to you to be a CA with experience of 15 years, CS with an experience of 15 years, or maybe a member of Indian Corporate Law Service or Legal Service for minimum 3 years at a pay scale of Joint Secretary at the Government of India. Now, a person of proven ability, integrity, having special knowledge and experience of 15 years in law, industrial finance, industrial management or administration, the industrial reconstruction, investment, accountancy and labor matters are being appointed as a technical or judicial member of NCLT. The 5 years standing as a presiding officer of a labor court or tribunal or national tribunal constituted under the Industrial Tribunal Act. It means these are the additional qualifications, like 5 years standing as a presiding officer of labor court, also being eligible for the technical or judicial. Now, the constitution of NCLAT. Now, it is an appellate tribunal. Those who are not satisfied with the judgment of NCLT will apply here. Now, the central government shall constitute the NCLAT. It shall consist of chairperson and members not exceeding 11. The central government shall notify such appointments, and the appellate tribunal has to hear appeals against the order of the tribunal. It provides the chairperson shall be a person who has or been a judge of Supreme Court or a High Court. Okay, the chairperson only from the Supreme Court or High Court. Now, the judicial member has to be a person who is sitting or retired judge of High Court or judicial member of tribunal for 5 years. It is clear? Now, the technical member shall be a person who will proven ability, integrity and standing, having a special knowledge, not less than 25 years in law, industrial finance, industrial management, industrial reconstruction, investment, accountancy and labor matters. Further conditions for being a qualification as NCLAT: the president and other members of the tribunal are to hold office for the term of 5 years from the date of which they enters upon the office. The age of retirement is 67 years for the president, while for the members it's 65 years. Now, it means that the retirement age is 67 for the president and for the members is 65 years. Any application before the tribunal should be dealt with and disposed of within the period of 30 days. It means if the application is filed today, within the 30 days, all the proceedings to be cleared. The president and the chairperson or any member of tribunal by notice in writing to address to the central government resign from the office. Anyone who want to resign should write to the central government, and once the application is been approved, they are removed or deemed completed their service of 10 years at the NCLAT.